Mr. Sandefur is an adjunct professor of law at the George School of Law in Sacramento. He's a graduate of Chapman University, and he is a graduate of Hillsdale College for his undergrad. Today he'll be telling us why we need to fight for our rights to pursue happiness. Please join me in welcoming Mr. Sandefur.
Thank you very much. Lana called me her colleague when in fact I'm her boss. She's doing a very good job, isn't she? I hold these truths to be self-evident, that all men are created equal, that they are endowed with certain inalienable rights, that among these rights are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That whenever government becomes destructive to these ends, it is the right of the people to alter or to abolish it and to institute new government, laying its foundation on such principles and organizing its powers in such forms as to them shall seem most likely to affect their safety and happiness. What does that mean, the pursuit of happiness? What does the right to pursue happiness mean? There's a lot of things that it means. It's really hard to nail it down, right? It means a whole indefinite range of action that you might pursue in order to pursue and obtain happiness and safety, as the Virginia Declaration of Rights put it, only a few months before the Declaration. You can't narrow it down to particular rights. Oh, I have a right to go on a picnic. I have a right to go on a picnic on a Thursday. I have a right to eat a roast beef sandwich at my Thursday picnic. You can't come up with a list of all of your rights because there's an infinite variety of actions that would have to be covered, and your list would have to be infinitely long. And you run the risk that if you left something off of your list, people would think that you purposely left it off your list, right? That's why we have the 9th Amendment to the Constitution. The reason that I make this point is because a lot of my conservative friends particularly, although also my liberal friends, like to say, oh, well, where is that right in the Constitution? Whenever I file a lawsuit, it's like, well, yes, it's true you have freedom of speech because the Constitution says that, but you don't have these other rights. Where's the right to economic liberty in the Constitution? The answer is, the Constitution protects, quote, liberty, end quote. And liberty does not come in discrete quanta. Liberty is an indefinite range of free action, and the Constitution protects that right as an enumerated right. Another person who understood very deeply what this idea of pursuit of happiness means was one of my great heroes, Frederick Douglass. Of course, Frederick Douglass was born a slave in Maryland. He escaped slavery because, as he said, he who would be free must himself strike the blow. So he obtained forged papers, that a passport from the U.S. Navy, and escaped to free New York State in the disguise of a U.S. Navy sailor. And when he got to Rochester, New York, his adopted home, he writes in his autobiography, actually I believe it's only in his third autobiography, The Life and Times of Frederick Douglass. He says he was walking down the street in Rochester, New York, and he saw that in front of a woman's house, there was a big pile of coal. Back then, you'd have coal delivered for your furnace, and the horse cart would come in front of your house, they would dump off the coal, and it was your responsibility to put the coal down the chute into the basement of your house. So he came along and he saw there was a pile of coal there, and so he went and he says he knocked on the door, and he asked the woman if he could help her by moving the coal into her house for some money. And she said yes, and so he said, I was not long in accomplishing the work when the woman put into my hand 2 silver half-dollars. To understand the feeling that possessed me when I clutched the money, knowing that it was my own, that my hands were my own and could earn more of the precious coin, that no master Hugh stood over me ready to seize my earnings, one must himself have in some sense been a slave. What Douglass was talking about in that passage is the incredible feeling of individuality, of responsibility and liberty that comes with economic freedom of choice. And when we talk about economic liberty and capitalism and economic efficiency and rent-seeking and public choice models and all this, what we're really talking about is the right of each person to make economic choices for himself or herself without somebody else telling them what to do. Now, I'm a lawyer. I'm in the business of suing the government. It is the best job in the world. I would do it for free if I had to. In fact, I do it for free. The Legal Foundation represents its clients free of charge, and we're supported by donations from people who agree with the things that we do. Those of you with checkbooks in your pocket can see them on that. And I want to talk to you about a case that I worked on not long ago in fact, in Lana's home state of Missouri, or as the founders called it, misery. Michael Muni is an entrepreneur who started a moving company in St. Louis, and he has a federal license that allows him to move from one state to another. You can pack up your stuff from St. Louis and take it to Florida if you want. And he has a Missouri state license that allows him to operate within the city of St. Louis. But he is not legally allowed to move somebody from St. Louis to any other part of Missouri unless he first gets a special state license called a Certificate of Public Convenience and Necessity. Any of you in here are law students? Any of you in here heard of a Certificate of Public Convenience and Necessity before? One or two hands, sorry. So you know that when you file an application for a Certificate of Public Convenience and Necessity, and these exist in almost every state, if you file an application with the Missouri Department of Transportation Motor Carrier Services Division to get a license to run a moving company, the first thing that the agency does is notify all of the existing moving companies in the state about your application and give them the chance to object. Now, surprisingly enough, a lot of the time they do object. Not real keen on new competition. And when they object, you, the applicant, are required to go to a government hearing where the law requires that you hire an attorney, which can be a very expensive undertaking for an entrepreneur like Mr. Muni. And at that hearing, you're required to prove to the government that there needs to be a new moving company in the state. Now, how would you do this? How would you prove to the government that there needs to be a new moving company? That's the right answer. Nobody knows. The statute does not say. No statute, no regulation, no judicial decision, nothing explains how you would prove this to the government. But just think for a second, if you had to do it, how would you prove it? It's not really possible, right? I first went to a Starbucks in 1993 when I was on a trip to Seattle. A friend of mine took me there. It's like, this is a great place. You got to try it. Take the world over. This is great. Go there. It was just coffee to me. If you had been required to prove in 1993 that America needed a new chain of expensive coffee shops, how would you have proven that? You could not have proved that. There were plenty of coffee shops in America in 1993, and it turns out America needed a new chain of overly priced coffee. How do we know that? Because Starbucks is wildly successful. That's the only way to prove that there is a need for a new business, is to try it and see if you succeed. But in Missouri, it is illegal to try it and see if you succeed. You first have to prove to the government that there's a public need. So we filed a lawsuit. We said this violated Mr. Muni's right to earn a living, as protected by the under the Liberty Clause of the 14th Amendment. Now, I'm sure you brought your constitutions with you, so if you'll take those out, you can see. Dangerous joke in an audience like this. I always carry my handy iPhone app. Constitution on iPhone. It got updated the other day, and I wondered why. The only thing I could think is the individual mandate must have been added to my Constitution. Anyway, the 14th Amendment says that all people born in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make it or enforce any law that shall deprive you of the privileges or immunities of citizens of the United States, or deprive you of liberty without due process of law, or treat you unequally. Now, I want to talk about the equal protection clauses. That would take forever. So I want to talk about the other two things. We sued under all three of those clauses. We said this violates Mr. Muni's rights under the Privileges or Immunities Clause and his rights under the Due Process Clause. What are the privileges or immunities of citizens of the United States? It's kind of a strange phrase, isn't it? The lawyers call it term of art, which means it's magic words that mean something. And privileges or immunities, when you look into the history of it, is a very old term that referred to the rights that English subjects possessed under the common law and that the Founding Fathers believed also included certain natural rights, your rights to life, liberty, and the pursuit of happiness. We know that from a case in the 1800s called Corfield versus Coriell, which was written by George Washington's nephew, Supreme Court Justice Bushrod Washington. And when you look at the history, one of the oldest rights protected as the privileges or immunities of English subject was the right to earn a living without unreasonable government interference. And these cases go back to Shakespeare's day. My favorite, a lot of them were written by the greatest lawyer in history, a man named Sir Edward Coke, who was Queen Elizabeth's Attorney General and later became Chief Justice of England. And he wrote a decision, my favorite one is called The Case of the Upholsterers. And what happened was it was illegal to upholster a chair for somebody unless you first had a license from the Upholstery Guild. And this guy wanted to do upholstery, and he wasn't allowed to, so he filed a lawsuit, and it went up to the English Supreme Court, like 1610 or something. And Chief Justice Coke was like, why do you have this law? What's the reason for this law? And what did the Upholsterers Guild say? Did they say this exists in order to prevent competition so we can raise prices and screw the working class? No. They said what groups like this always say. They say it protects the public. From what? From bad upholstery, I guess. Lord Coke said, no skill there is in this, for a man might learn it in 6 hours. And then he said, in one of my favorite lines from any court decision ever, he said, unskillfulness is sufficient punishment. Very profound. Unskillfulness is sufficient punishment. There's no reason for the government to get involved. If you're bad at upholstery, nobody's going to get stuff upholstered right. Or if they're happy with the quality of your work, they'll shop and they'll buy from you, and fine, whatever, right? Ain't nobody's business if you do. And that was only one of a string of cases around the 17th and 18th century that I detail in my brilliant book, The Right to Earn a Living, that the Founding Fathers were very familiar with. In fact, Lord Coke wrote what became the legal textbook for the Founding Fathers when they were going through law school. At one point, when he was young, Thomas Jefferson said he couldn't stand how boring reading Coke was. So we know that the Founding Fathers were familiar with this legacy. And when they talked about the right to earn a living, or the right to pursue happiness, they meant, among other things, this right of economic liberty. Have you ever read the summary view of the rights of British America by Thomas Jefferson? This was sort of a rough draft of the Declaration of Independence. It was a pamphlet Jefferson wrote that was why he was well enough known that he was then chosen to write the Declaration. And in the summary view, he gives a long list of reasons why they should declare independence from Britain. And one of them is very interesting. He says, it's illegal to make things out of iron in the colonies. The law requires us to ship our iron to England to be made into things and then shipped back as finished goods in order to protect the jobs of licensed ironmongers in England. So we know that economic liberty was one of the central values of the American Revolution, the right to pursue happiness. It was one of the rights that was the privileges or immunities of American citizens. And after the Civil War, when the Constitution was amended in order to protect us not just from the federal government, but also from the states, the 14th Amendment added a privileges or immunities clause that said no state can deprive you of the privileges or immunities of American citizenship. Then the problem started with the Supreme Court. In 1873, there was a case called the Slaughterhouse Cases. And what happened in the Slaughterhouse Cases was the state of Louisiana passed a bill that said, if you want to slaughter cattle in New Orleans Parish, you have to do it at a single, privately owned corporation called the Crescent City Livestock Landing Slaughterhouse Corporation that, by coincidence, just happened to be owned by members of the state legislature. Now, you would have to imagine if the state of California passed a law that said all automobiles in Northern California must be repaired at Joe's Fix-It shop. Right? Cattle slaughtering was a huge industry in New Orleans in the 1870s. You bring cattle down from the Great Plains or over from Texas, and you slaughter them in New Orleans, put them on ships, and send them to markets, right? So this was a huge deal. It put hundreds of butchers out of business overnight. And they filed lawsuits that all got put together as a single case called the Slaughterhouse Cases. And their argument was very clear. They said, look, we have the right to earn a living without unreasonable government interference. That means the government can restrict or regulate certain trades in order to protect the public against fraud or, dangerous practices or whatever, but they can't just give people economic privileges because they want to. This law does just that. It doesn't have anything to do with public health and safety. It's just a monopoly to a private corporation. It therefore violates the 14th Amendment's privileges or immunities clause. And they lost. In a 5-4 decision, the Supreme Court said that the Privileges or Immunities Clause only protects a very narrowly limited set of federally created rights, such as the right to travel on the high seas. Right! It's after the Civil War, when the radical Republicans were ratifying the 14th Amendment, they were worried about the state of Arkansas sending its state navy after escaped slaves who were taking vacations in Tahiti. What sense is there in this? This decision, Slaughterhouse, has no citation to the debates over the meaning of the constitutional clause. Nothing like this. It's just the reason behind the decision is that the Supreme Court said, well, 5 justices of the Supreme Court said, well, it would change our federalist structure, so therefore it can't be. And of course, the whole point of it was to change the federalist structure. My hero, my very favorite Supreme Court justice, the first Californian on the Supreme Court, Stephen Field, also the only Supreme Court justice ever arrested for murder, wrote the dissenting opinion in Slaughterhouse saying, the right to earn a living without unreasonable government interference is the central privilege of being an American. And if we do not adhere to it, we are a republic only in name. I'm sorry to say that the Slaughterhouse case remains valid law to this day. The Supreme Court has not, since 1873, with only minor exceptions, has never enforced the Privileges or Immunities Clause of the 14th Amendment. So if you've got your pen, you can just scratch out that part of the amendment. They always say to law students, the only thing you need to know about that clause is it's the wrong answer on the bar exam. I say that joke for Lana, who is currently waiting for her bar results. Just 2 more weeks. Take the time. So we can't win under the Privileges or Immunities Clause, so now what? We also argue that it violates the Due Process Clause of the 14th Amendment that says you cannot be deprived of liberty without due process of law. Now, a lot of my conservative friends are really confused about this clause, and they like to call it the Due Process Clause, when that's not what the clause says, right? That leaves out the most important words of the clause, due process of law. That means the government can take your liberty away as long as it accords you due process of law. Now, what is law? This is an easy question, right? Well, obviously that's a complicated thing. It's something that lawyers and philosophers have debated a long time. But we have a general idea of what we mean when we use the word law. We mean not arbitrary. Not just because I wanna. Not just because I got the guns and I make the rules. That's not law. That's arbitrary force. Law means the use of government's powers in the service of some broad principle of public benefit, right? That's what law means. It doesn't mean the government just coming in and taking what it wants. How do we know that there's a difference between law and mere force? By reference to the Declaration of Independence. The Declaration of Independence serves as the philosophical foundation for understanding the Constitution of the United States. Right? The Constitution says, we the people of the United States. Who is this we the people? Where did they come from? They're the same one people who dissolved their political bands with another in the Declaration of Independence, right? What authority do we have to create a constitution because we are now an independent nation from the Declaration of Independence? Secure the blessings of liberty to ourselves and our posterity. What liberty is this? This is the liberty that is referred to in the Declaration of Independence. The Declaration of Independence is regarded almost unanimously by left and right alike among the intellectual classes, lawyers, judges, law professors, political science teachers, as being nothing more than meaningless political rhetoric. Conservatives particularly despise the Declaration of Independence as the central source of all the evils in our political world. Read Judge Bork's book, Slouching Towards Tomorrow, where he centers all American social problems on the truths of the Declaration of Independence. Right? The Declaration of Independence gives us the framework for understanding what law is. And we know this from reading the other writings of the founders. We know that the founding fathers thought of government as kind of like a bank guard, right? Imagine that you own a bank, and you're afraid somebody's going to rob your bank, so you hire a guard, right? He goes and he stands in the corner of the bank, he's got his badge, he's got his guns. Problem solved, right? Not really. Now you have another problem. There's a guy in your bank with a gun, right? He could very well take out the gun and rob the bank for himself. When I was researching an article recently, I discovered that there was actually a case where this happened. In Florida, of course. The weirdest state. There was a bank, hired a guard, and the guard conspired with some other people to rob the bank. Right? And so the bank sued the guards, the company that the guard worked for, saying that this was a tort and that they were responsible. And the bank said, hey, we didn't tell them to do that. Right? Now, what would have happened if the bank had fired this guard and the guard had said, wait a minute, you didn't write here in my employment contract that I wasn't allowed to rob the bank? I guarantee you it wasn't written in his employment contract. What would your answer be? Well, duh. That would be your response. It would say, the reason I hired you is to guard the bank. It makes no sense for me to hire a bank guard so that he can rob the bank and there's nothing we can do about it. That'd be crazy, right? The same exact logic applies to hiring the government in the employment contract of the Constitution. And we know the founding fathers thought of it this way because they said so in Federalist 51, right? Madison says, well, again, conservatives love this line, but then they ignore the other part of it. So Madison says, if men were angels, no government would be necessary. Conservatives love to stop right there. What he says is, what he goes on to say is, if men were to be governed by angels, they wouldn't need a constitution. Right? The classical liberal argument has always been, from the days of Locke onwards, not that government is just inherently evil, but that if people are incapable of running their own lives wisely, they're all the more incapable of running other people's lives. Right? That's the idea. The idea is, and I say this to my liberal friends, I'm like, okay, let's assume you're right. Let's assume corporations are all evil. No doubt there are some evil corporations out there, right? The Bin Laden Corporation, right? There are some evil corporations out there. Why would you ever think the government is better? You can't fire it. You can't refuse to pay it. You can't quit. You can't hire some other government. You can't even sue it most of the time, unless you got a brilliant lawyer like me. Right? Why would you think you can trust government if you can't trust your fellow citizens to run their own lives? Why would you think they can run lives where they have no incentive to get it right? And so that's what Madison's point is in Federalist 51. In order to create a government that is to be administered by fallible human beings, you have to make sure that it can protect people from one another, but also that it will protect people from itself, just like the bank guard. That means there are implicit principles in what we mean when we refer to law. We mean not an arbitrary use of government power to benefit whoever happens to have the political influence to get what they want. That was the general understanding of the Due Process Clause, and that's why in 1874 there was a case called Loan Association versus Topeka. I love Loan Association, one of my favorite cases, because the question in that case was basically, are taxes constitutional? Right? This is the kind of thing that judges would talk about in the previous centuries. They actually had these deep philosophical, interesting decisions, unlike today. And in Loan Association, the question was whether government can take taxpayer money from some people and invest that money in a privately owned railroad. And the court said no. The court said, to take from A and give to B is no less a robbery, simply because it is done under the forms of law and is called legislation. This is not a law, it is a decree under legislative forms. Now, if it's not a law, then it takes away your property without due process of law, right? That's what the idea of due process of law means. That's why in Lochner versus New York, you're all supposed to go, boo, when it's a Lochner. Lochner versus New York. Oh, it's such a bad, evil decision, evil, right? Law students are taught that Lochner is the worst decision in the American history except for Dred Scott. What happened in Lochner was, this baker wanted to work overtime. It's against the law. New York passed a law saying you're not allowed to work more than 10 hours a day at a bakery. It's 1905. Not a single person in here would want to work in a New York bakery in 1905. Right? But Amon Schmitter, a German immigrant who worked for the Joseph Lochner Bakery Company in Utica, New York, wanted to work overtime. So he went to his boss, and his boss said, okay, why did he do that? Why did Amon Schmitter, a German immigrant, want to work overtime at a bakery?
He needed more money.
No, he was being exploited by evil capitalists. Right? So Joseph Lochner was brought up on charges for allowing this to happen. Here you have two grown adults who have the right to do with their own bodies what they choose, and it ain't nobody else's business if they do. Nevertheless, he's brought up on charges, goes up to the U.S. Supreme Court, and the Supreme Court says this law is unconstitutional. Why is it unconstitutional? Because you have a right to do what you want. You have a right to earn a living without unreasonable interference. The government can regulate the industry in order to protect the public, but there's no evidence that this law protects the public, therefore it's unconstitutional. It's as simple as that. This is the decision that conservatives and liberals alike regard with horror and shame. I love law members of New York. The license plate on my car is the case citation for law members of New York. 198 US 45. Most Supreme Court decisions wouldn't fit because they have 3 numbers, but this one only 2, so it was alright. It wasn't already taken! Anyway. This was the understanding of due process of law at the turn of the century. So how is it that we got from a time where the Supreme Court said government has no power to take property from A and give it to B, to a time where that's basically all that government does today? How did we get here? The answer is the Progressive Revolution. Progressivism was an intellectual shift that began in about the 1880s, 1890s or so, and really still continues to the present day. And progressivism basically had 4 big principles. The first one was rights are just permissions that the government gives to us for its own reasons. The founding fathers thought that we all had rights because we're human beings, but the progressives thought that rights are given to us as privileges by the government. Justice Oliver Wendell Holmes, the vilest human being ever to serve on the Supreme Court of the United States, a disgusting moral monster, whose words are quoted on the front of the law school building across the street by people too ignorant to know what an animal he was. This is a man who he believed that there was no such thing as morality. Morality was simply the force exerted by the majority, however it chose. And so he wrote a decision called Abrams versus the United States, a dissenting opinion called Abrams versus the United States, which most law professors today regard as the fountainhead of modern free speech jurisprudence. Because Holmes was a great defender of free speech. When you read his decision, one of the first lines in it is, quote, "Persecution seems perfectly logical to me," end quote. He then says, but we don't persecute people because it's good for society to allow a debate. So we let people debate. But of course we can take that right away from them whenever we want. And so he also wrote Schenck versus United States, the case that's famous for the line, yelling fire in a crowded theater. Does anybody know what Mr. Schenck was doing that the court said was yelling fire in a crowded theater?
Protesting the World War I draft.
He was handing out pamphlets to protest the draft, because that's just like yelling fire in a crowded theater, right? This is all over Wendell Holmes. You can see what he's doing. What Holmes is doing is he's transforming freedom of speech from a right into a privilege that the government gives to you for its own purposes. That was the first progressive idea. The second progressive idea was government exists to make society nice. It's not what the founders saw, right? Jefferson said the sum of good government is one which shall restrain men from injuring one another and leave them otherwise free to regulate their own pursuits of industry and improvement and not take from the mouth of labor the bread it is earned. But no, the progressives had these brilliant new ideas for how government ought to operate, and so they came up with these fantastic new schemes, such as eugenics, segregation, prohibition, the income tax, government control of the money supply, zoning, did I mention zoning? Eminent domain for redevelopment. Right? The term blight was first applied to property in the progressive era because the progressives thought of government as a gardener and society as a plant. And the gardener goes and prunes and shapes the plant to serve the elite's desires. So government exists to make society nice. The third great progressive idea was the idea of judicial restraint. Justice Holmes famously said, if my fellow Americans want to go to hell, I will help them. That's my job, end quote. Now, maybe some of you haven't read the Federalist Papers, so I'll tell you now that the phrase go to hell is not in there. In fact, in Federalist 78, we're told what the role of the courts is. The courts exist to protect people against the legislature. That's why we have courts. Because the legislature is not the will of the people. You always hear people, oh, the evil activist courts interfering with the will of the people. No, they're not. The Constitution is the will of the people. A law is just the will of a particular legislature at a particular time. If the law is inconsistent with the Constitution, then the law is not the will of the people, and it is right for the courts to strike that down. But this is, of course, obscured by the progressive rhetoric of judicial activism. Oh, okay, judicial activism. One of these days I'm going to make a poster, Great Moments in Judicial Restraint. Right? Because that's what conservatives want, is a judiciary that, when the government comes along and violates its rights, stands back and goes, whatever, okay, I'm not going to do it, right? That's judicial restraint. Great moments of judicial restraint. Plessy versus Ferguson. The state's going to discriminate against people on the basis of race, and the court says, we're not going to be activists. We're going to let the Democratic majority have its way. Right? Korematsu versus the United States. The government decides to throw all the Japanese Americans in prison camps in World War II, and the court says, no, we're not going to be activists. We're not the president. We're just judges. Evil life tenured judges. Buck versus Bell. Anybody hear of Buck versus Bell? That was the case in which Justice Holmes said it was perfectly constitutional for states to force women to undergo sterilization operations against their will. He said, quote, 3 generations of imbeciles are enough, end quote. It was the only decision he was really proud of because Holmes was very much an enthusiast for eugenics. That decision has never been overruled. So that was the third great progressive idea, was judicial restraint. And then the fourth great progressive idea was the living Constitution. Constitution doesn't mean today what it meant yesterday, bends and changes with the needs of the day, right? Those are the progressive ideas. Rights are just permissions from the government. Government exists to make society nice, etc. Justice Brandeis famously said, property and other rights of the individual must be remolded from time to time to meet the changing needs of society. I just love that word, remolded. Remolded. The great euphemism for violated. Doesn't that sound like the crap you were taught in high school? Yeah. Oh, well, yes, you have rights, but your rights have to change for the needs of society. Right? If your right can be molded to shape society's needs, it's not a right. It's a privilege. You, of all people, know the difference between a right and a privilege. Because you only now have rights. Only a few years ago, you didn't have any rights at all. You had to ask permission for everything. And that's what the progressives are doing, is they're making rights into privileges. I own a house about 2.5 hours away from here. Sometimes I sleep the night on my couch just because I can. I love my freedom. I love taking out my freedom every now and then and just playing with it. It's getting smaller and smaller every time they keep updating my Constitution app. So the elevation of democracy over liberty was the central goal of the progressive movement. What the progressives managed to do was to convince the country that democracy was more important than liberty. In fact, that democracy was the source of liberty. That rights are what privileges are given to you by the majority. This was, of course, exactly the reverse of what the founding fathers thought. They said all men are created equal with certain inalienable rights, and they create government because they have those rights in order to protect those rights. Not anymore. The progressives threw out the idea of natural rights and adopted an idea of positivism that says your rights are just what government gives to you, and democracy takes precedence. In a 2006 interview, I heard Justice Stephen Breyer say, he was asked what the most important part of the Constitution was, and he said democracy. A word that doesn't appear anywhere in the Constitution of the United States. The first sentence of the Constitution says unambiguously that liberty is a blessing. It doesn't say the same thing about democracy. It goes on for page after page after page, limiting democracy, putting all sorts of restrictions on democracy. Why? To protect liberty. But today's intellectual elite has swallowed progressivism to such a degree they cannot understand this idea at all. And what is the result of this in practical terms? In philosophical terms, I've already explained, but in practical terms, what does it mean? When the government is allowed to redistribute wealth or economic opportunity from one group to another, what is going to be the consequence? Rent seeking, right? Rent seeking, or what the founders called the mischiefs of faction. This is a problem that politically powerful groups are going to use the government to benefit themselves at the expense of their rivals, and that's just what we see in the economic realm as a result of the abandonment of constitutional protection for economic freedom of choice. So I did this case that Lana mentioned earlier called Merrifield. In California, if my client, Alan Merrifield, he was a pest control guy, he put those spikes on buildings to keep pigeons from landing on them. You see these in cities, right? Well, in California, if you want to put spikes on a building to keep pigeons off, you have to get a Branch 2 structural pest control operator's license, which requires 2 years of training learning how to handle pesticides. And then you have to take and pass a 200-question multiple-choice examination testing your knowledge of the use, storage, and handling of pesticides and the lifestyles of insects, and criminal background check, fingerprinting. etc., even though you don't use pesticides. And it gets better, because the law only applies if you're dealing with pigeons. If you're dealing with seagulls, starlings, or any other kind of animal, you don't need any license at all. The statute said that. Pigeons, rats, and mice. So, we sued. We said this was unconstitutionally irrational. We had the government come in with their expert witness at our deposition. Very interesting deposition, because this guy basically wrote this law that we were challenging. So I said to him, now, this law requires 2 years of training to put the spikes on the building to keep pigeons from landing on it. He said, yes, that's right. I said, but no training at all to put the same spikes in the same building to keep seagulls off of it. He said, yes, that's right. I said, do you call this law irrational? He said, yes, I would. The government's lawyer says, can we take a break? We come back from the break and he says, I'd like to clarify what I said about irrational. I bet you would, right? He says, what I meant was, from the public's perspective, it might seem irrational, but what really happened was, originally you needed a license for all pest control work. And then there were people who said, well, if you're not using pesticides, you're not a threat to the public, so we should get rid of the licensing requirement. And those of us who already had licenses, we didn't want to have competition from people like your clients. So we went to the state legislature and we said, can you divide up the market? Let us keep the pigeons, they're the most common pest bird, and they can deal with all the other ones. I'm like, tell me more. So I went in front of the judge and I said, Your Honor, it is an undisputed fact in this case that this law is positively irrational. And we lost. Because of the rational basis test, which says that the judge has to come up with his own justification for the law. And what he said was, well, it's true that you might not need to know this stuff if you're dealing with pigeons, but if you're a pest controller, you might show up at a project site where other people have used pesticides, and you would have to know how dangerous they are. So you would need the training. Even if that were true, the license is only required if you show up for a pigeon job. If you show up for a bat job, the walls could be dripping like in Ghostbusters, and it wouldn't have to have any license. So we appealed that to the Ninth Circuit Court of Appeals, and we won on appeal. The Ninth Circuit struck that law down and said it's unconstitutional for the government to use occupational licensing laws in order to protect some groups against fair economic competition with others. So, that was a major victory because that is one of only 2 cases, well now 3 sort of cases, that has ever said that. The other one being a case in the 6th Circuit a few years earlier. But the 10th Circuit Court of Appeals, Oklahoma, has declared that government may use its licensing laws solely for the purpose of giving economic favors to favored groups, even if the law has no connection at all to protecting public safety. And that split among the circuits is still there today. The Supreme Court refuses to take up the issue. So that's the law we have today. So, now that you have all that background, let's get back to our favorite state of Missouri and Mr. Muti and his moving company. We filed a lawsuit challenging the constitutionality of the Certificate of Necessity law. And we asked the government to send us documentation of every application for a moving license in the past 5 years. And they sent it in. I think it was 75 or so. Actually, I think it was exactly 75 applications for moving licenses. And of those 75, 60 of those companies had asked for permission to operate a moving company within a very narrowly limited area or in a rural part of the state, that's kind of far away from the big cities. And they got licenses no problem. Nobody objected to those. The other 15 requested licenses to move across the entire state, and every one of them was subjected to 1 or more objections by existing moving companies. And it was astonishing to read these objections because they didn't even pretend that it had anything to do with public safety. They said, we object because we don't want competition, in one after the other, after the other, after the other of these objections. And in all of those cases but 2 or 3, the applicant withdrew his application as soon as the objection was filed and erased the part about statewide and said, okay, well, just let me work in St. Louis. And then the objectors withdrew their objections and he got his license for St. Louis. Only 2 people went through the entire hearing process to get a license. One of them got a license in a written decision that says, well, and after looking at the record, you're perfectly safe, you got all the required insurance and everything, and competition's a good thing for the state, so granted. And in the other decision, the administrator said, well, you're perfectly legal, you're perfectly safe, you got all the required licenses and insurance, but Competition is a bad thing, therefore deny it.
So where does that leave us?
It leaves us with a completely arbitrary and vague law that cannot be understood by the layman, right? It leaves us with a situation that does not deserve the dignity of the name due process of law. So in April, I went and argued that case in the Federal District Court in Missouri, and I'm relieved to say that we did not get a decision in that case because the state legislature backed down and repealed that licensing law. And now, all you have to do is prove that you're safe, and you can automatically get a moving license in the state of Missouri. So we followed up with 2 new lawsuits. We're now suing Kentucky and Nevada over their licensing laws for moving companies. We also succeeded in a case in Oregon some years ago. So we're suing now in Nevada and Kentucky. The Nevada law is particularly amusing because that law is the most anti-competitive licensing law in the United States. That law says if you want a moving license in Nevada, you have to prove that you would not compete with existing moving companies. Then it says below that, and there's several things you have to prove. You have to prove you would not compete against existing moving companies. You have to prove you would not compete against existing moving companies. You have to prove you would not compete against existing moving companies over and over and over again in the statute. And then it says you have to prove that you would comply with the standards set forth in some other statute. If you look at that other statute, it says, it is the policy of the state to discourage competition in the moving industry. My client, Maurice Underwood, wants to run a moving company in Reno. There are 2 licensed moving companies in Reno. There are 40 licensed moving companies in the entire state of Nevada, a state with a population of 2.9 million people. Because the state sees fit to tell us when we need a moving company. That is outrageous and unconstitutional. Every person in this country deserves the right to earn a living as he sees fit, so long as he harms no other person. And yet today, thanks to judicial abdication of essential constitutional liberties, politically powerful interest groups use licensing laws like this to exclude their competition. And of course it harms us as consumers. We can't get the moving services we need at prices we want to pay. But more importantly to me, is it violates the rights of hardworking entrepreneurs like Maurice Underwood, who isn't asking for a bailout. He's not asking for some handout. He's asking to be left alone to put his own skills to work, providing for himself and his family, and it ain't nobody else's business if he does. Now, Frederick Douglass, let me pause for a second and talk about what I do. Because I mentioned Frederick Douglass at the beginning, and I see the disputes within the libertarian community as being an echo of a very long-standing fight that's gone on since before the Civil War between Frederick Douglass and William Lloyd Garrison. Garrison, of course, is a great abolitionist who argued in favor, he argued long before the war, he argued that the North should secede from the South because slavery was so awful. He said no union with slaveholders. He said people shouldn't vote or participate in the political system because doing so was basically to lend your own moral support to that system and to concede its validity. And Frederick Douglass disagreed with this. Frederick Douglass said that, first of all, he said, the Constitution interpreted as it ought to be interpreted is a glorious liberty document. And he argued in favor of political involvement. He said, Garrison's logic was that the abolitionist movement started out to free the slaves and now leaves the slave to free himself. He said, if we with others have robbed and raped and pillaged, it is not our duty to stand back and say, oh, no more union with robbers, rapers, and pillagers. It is our duty to restore the stolen property. Right? So he argued in favor of political involvement. Now the downside of political involvement, the downside of doing it my way, the downside of going to federal court and suing, is it's dirty and extremely disappointing a lot of the time. I'll tell you right now that I've been practicing law for 10 and a half years now, and I have won a single case in my career, and that was married to. And that's because you people who are not lawyers have no conception how alienated the legal community is from the principles of the Constitution and the Declaration of Independence. How hard it is to go to court and say, my client has a right to earn a living. The Lochner decision was rightly decided. The Privileges or Immunities Clause should protect people's natural rights. These are ideas that are laughed and scorned by the leading intellectuals in the legal community today. So it's very hard work, and it's very disappointing, and it's difficult. And it's true that in some sense, you are staining your own soul by involvement in a system that you believe is morally corrupt and intellectually indefensible. On the other hand, Garrison's path of having no involvement at all accomplishes nothing. at least in my view. Douglas said that what that's doing is saying your own moral purity is more important than accomplishing real results for real people who need help now. And what I do is frustrating and not always intellectually or morally defensible. But what I do is to try and defend people who need help now from a Leviathan state that is violating their fundamental human rights. I do not mean to cast aspersions on the Garrisonian view. If you are of the view that morality requires you to have no part in the political and legal system, and that you should keep yourself free from it and be a witness to the principles of liberty from outside that system, I perfectly well respect that. I ask that you respect my choice also and see that there's also an important role for those of us who say, you know what, the system is incredibly imperfect. There's no way to go into a courtroom without some tinge of abandoning the principles of the Constitution because of the mess that we have made in that document. But it's important to try and make a real change now. Some of you have studied Marxism. You know that Marx was opposed to crime because he believed that crime led off the steam that would have otherwise led to proletarian revolution. There's a certain logic to that. Going to court and fighting for the rights of people like Michael Moody and Maurice Underwood and Alan Merrifield, maybe that just prolongs the problem because it allows the system to claim moral legitimacy. I don't know the answer to that problem. I know my answer. My answer is to be involved in the state, in the situation, and to go into the state's own courts and fight the state and order it to obey its own promises and be rejected time and time again. That is a central decision that you, as young libertarians, are going to face as you choose your career and as you choose your future. I hope some of you will consider a career in public interest law, challenging the constitutionality of these laws, suing the government for a living. It's great to watch the bureaucrats squirm. Oh, it's so fun. Being sued. It is the greatest job in the world. But it's also not a very great paying job, and it is very frustrating sometimes. I lately have been extremely discouraged by the Obamacare decision and things like that. But I think whether you choose the Douglas side or the Garrison side of that dispute, whether you choose to stand outside and criticize the system or stand inside the system and try and work within it, either way, we all can learn from the great advice of Frederick Douglass, who, as an old man, was asked by a young man what he should do with his life, what career should he choose, and Douglas said, agitate, agitate, agitate. That's all. Thank you.
The Constitution is of no authority since it was not agreed to by the majority of the people that live in it and could not be made binding upon people subsequent generations.
Right. The question is, what do I think about Spooner's argument that without actual, genuine consent, the Constitution lacks moral legitimacy? My answer to that, again, is an imperfect one, and that is, there's a famous letter that Jefferson wrote to Madison about the earth belongs to the living. And people always read Jefferson's letter, but they often don't read Madison's response. There is the earth belongs to the living, so we should tear up the Constitution every generation because it doesn't have genuine consent. And Madison's answer to that was, as a practical matter, there are just too many problems with that. For one thing, it would mean nobody would lend money because you wouldn't be able to predict whether debts would be abolished by the next Constitution, right? And there are all sorts of problems, legal doctrine and things, with that idea. And so he said, although the answer of tacit consent is very imperfect, it's really the best we have, and that's my answer. Now, added to that, my answer to that is somewhat skewed by the fact that I happily endorse the Constitution of the United States. I took an oath when I passed the bar to support the Constitution, and I enthusiastically believe in supporting the Constitution because I agree with Douglas that it is a glorious liberty document. Yes, he's owned that book.
Right.
A lot of broad books for some people.
But of course, the first 4 questions also just come see me after. So
Okay, all right. Yes, back here.
All right. So how do you feel about the varying licensure laws that apply to your profession, the bar exam?
Right.
Would you ever challenge that?
The question is, what do I think about the bar exam? I think the bar exam should be abolished. If the bar exam were really about skill and knowledge, then it wouldn't be a once-in-a-lifetime test. you would be required to take it more than once. We know it's not a test that's about protecting the consumer because in Arizona a few years ago, too many people passed the bar exam. And what happened? Did the state bar say, wow, this is great. That means the supply of legal services will be increased, the prices will drop, and poor people will get the legal services that they so emphatically need. And no, their answer was to raise the passing score. So the reason why is because the state bar is a cartel that is designed to protect some people against competition from others. I am perfectly confident that I can out-lawyer most people, regardless of the bar exam. And it's true, the bar exam is a hard test. It is a test of skill to some degree. It's truly absurd the way that some of these licensing laws are. And of course, it is the last target on my list. Because I'm not going in front of a judge and saying, Your Honor, you should get rid of the state. Oh, it's not going to happen. But you know what? The greatest lawyers in American history, John Marshall, Stephen Field, they didn't pass some state administered bar exam. They took some pro forma test, and then they were on their own to test their skills in the fair market. Yes?
You were saying that the elites in law and political science and other areas don't really understand the ideas of liberty. So I was wondering what you would recommend to young people, whether we should go to law school at all.
The question is if the elites lack the knowledge of the principles of liberty, should you go to law school? Oh, sure. I don't see you. Undergraduate schools have no concept of the principles of liberty. In fact, undergraduates are probably worse off. Because lawyers are forced to deal with the Constitution, whereas in your political science classes and stuff, they can just ignore it. So there's at least that aspect of it. Plus, there is one thing that actually makes me very optimistic, and that is the rising generation of libertarian lawyers. In the past 10 to 15 years, we have seen a group of talented young libertarian lawyers that have done amazing things in the courts across this country. That is probably the only thing we can figure out sometimes, is that I run our law clerk program at the foundation. Very often, people come in to apply for a job as a law clerk, and they say, I went to law school because I was so mad about the Kilo decision. So I think that's a very good thing. And the lawyers, like it or not, are a very critical class in this society. And so the more impact we can have on them, the better the future will be. So absolutely go to law school. And there are some very pro-liberty law schools out there. On the East Coast, George Mason, and on the West Coast, Chapman University, my own alma mater, which is very friendly to libertarian and free market ideas. It's the only university in the world with a bus of Ayn Rand on campus. Yes?
I have two questions for you. One of them is, amidst all the frustration that you face, what do you do to get rid of that frustration? This is personally, so a human being.
What's your second question?
Second question is that you mentioned that for, especially in this time, a lot of people attribute democracy as being the source of liberty. And I feel like a lot of other states and peoples outside the United States are also endorsing that. So how would you go about spreading this notion of liberty to those types of people as well?
Well, I'll answer the second question first, and that is, there's a great passage in Nietzsche, and Human All Too Human, where he talks about the difference between the free spirit and the bound spirit. And he says when the free spirit has to plead his cause at the bar of bound spirits, he has to obey certain rules, and one of them is the bound spirit, the unfree mind, thinks that something is good because it is permanent. And therefore, a free spirit has to prove to the bound spirit that free spirits have always been around. Well, that's what I do. I read the Founding Fathers, and I say that the Founding Fathers, James Madison said, in other countries, the idea is that charters of rights were granted by power. And America has set the example, and France has followed it, of charters of power granted by liberty. And what he's talking about is that inversion, the idea that people are basically free, which most intellectuals in the country today have abandoned. In the opening lines of, you read John Locke's second treatise of civil government, many people don't read his first treatise. And his first treatise is a refutation of the ideas of one of these people who is very much like modern thinkers. And Locke says, his system lieth in but a little compass, and it is this, that no man is born free. And that is the idea that prevails in the intellectual community today. The rights are given to us by the government because no person is born free. So my answer, how do we persuade other people, I think, is read the Founding Fathers, primarily. They really understood these ideas very well. And then read the abolitionists, particularly people like Douglas, Joel Tiffany, as for how I keep my spirits up, for one thing that helps is it's so silly what the government does a lot of the time. It's like they have nothing better to do. I just lost a case this week where my client sells worm poop. It's a fertilizer that a lot of gardeners use to keep bugs away from their plants. And in the state of California, it's a pesticide.
What?
Why? Not because it actually is a pesticide, but because my client said you could use it to keep bugs from your plants. And if you say you could keep bugs away with it, it's automatically a pesticide under California law. So, under the court's decision from this week, this piece of paper is a pesticide the instant I say you could smash a bug with it. Now it's a pesticide, and now if I were to sell this to you, it would be a violation of California law. I'd be fined thousands of dollars. So, that's so stupid. How can you not laugh at that? I mean, it's ridiculous, right? But, no, I do often think about Homer Simpson's advice when he says, your mother has to learn to bottle all her rage down deep inside and release it at an appropriate time. Yes.
Basketball conference, when you spoke about the Obamacare thing, and I was curious about what your...
You were the one I was trying to avoid. Hoping nobody would ask about Obamacare.
No, I'm just curious
No,
about
that's-
James Roberts.
So here's the thing about Obamacare was actually a 2/3 win for our side. And we're so disappointed in the way it worked out that we tend not only to overlook that, but sometimes to mischaracterize the decision, which is very dangerous for our side to do because we're still fighting this case. These cases are still going forward. I'm litigating one right now in the DC District Court, Federal District Court. My wife is litigating one right now in the Arizona Federal District Court. So these cases are going forward right now. And it's important for us not to undermine our own side. What happened was the Supreme Court did strike down the individual mandate. They said, Congress lacks power to force you to buy insurance. 5-4, they said that. Then they said, but they can tax you for not having insurance. Now, that's the kind of distinction only a lawyer can love, right? But what Roberts explains is that he thinks it's different for this reason. He says, you can still refuse to do it, and it's true, you have to pay a tax for that, but if the tax were so high as to actually constitute a mandate, I would strike that down also. So what he's saying is that there's a limited power of Congress to tax non-behavior. And he says limited. Now, of course, that's only worth the paper it's printed on until it gets enforced, right? But nevertheless, that is an important distinction, at least theoretically. It certainly is not a blank check for mandates. And that's the most important thing, is what didn't happen in this case. What would have happened in this case if this had not gone the way it did? We would have had a federal problems clause. We would have had a constitution that said the federal government can do whatever it wants. And we now only have a constitution that says that the federal government can do virtually anything it wants. But as Randy Barnett points out, imagine that the drug war were run this way, right? There's no law against using drugs, you're just taxed for it. That would be a different world. It would be hardly a perfect world. It would be a very different world than the one we have today. So it is an important doctrinal difference. Then we also won hugely on the spending clause aspect of the case, which had never been enforced in American history before. We won that 7-2. So I think I try to look on the bright side and say 2/3 of that case we won. Now it's true that we are still subject to the tax for not having insurance, and that's not a pleasant aspect, and it's not a pleasant prospect. But it's also unlikely to be repeated in future legislation. I think it's not words, but I think that we probably dodged the bullet and got hit in the leg a little bit on this one. That's it. All right. Thank you all so much.